It's really awesome. Thank you so much, everyone in Birmingham. I do love coming every year, make it a fall tradition. And I just want to say a note of joy, if I can, at the outset. Not for the election, that's not what I'm talking about. It's for the Supreme Court. When I've given this talk in recent weeks and months, I've always started by saying, you know, we're used to a court with 9 members. We know those 9 members are. It might change one at a time. We know that there's no sort of body sitting over the court deciding who should sit on cases. The court's predictable. It's been the same way for, about 150 years or so. But that wasn't necessarily the case. There are very strong movements afoot to, as I say, reform the court. Reform is a euphemism, of course. FDR tried to reform the court. The reform might be to expand the number of members. Reform could mean you add a retirement age by statute, which I think is unconstitutional. So you take the oldest justice, say, congratulations, you're now senior, good job. And then you add 6 more members at the bottom. Reform could be creating some sort of a body to supervise the Supreme Court and decide when they can sit on cases. All those mechanisms are transparent and patent efforts to negatively respond to certain decisions. We didn't need that for the Warren Court, we didn't need that for Roe v. Wade, but oh my goodness, Dobbs, Bruen, Kennedy, we got to burn this place down. And I can say for at least 4 more years, the court is safe, I think. But I'll be back here in 2028 or so, and I'll see what the deal is. All right, very good. Is there a door there? Well, it's really noisy.
I think it's the air. Okay.
A lot of noise going. Anyway, so let's go on. The term last year wasn't as controversial as years past. The 2021 to 22 term, I think, was probably the apogee, the high point of the court sort of doing stuff. And I refer to the busiest 72 hours in my life, where you had, in the span of 3 days, you had the Dobbs decision on abortion, you had the Bruen decision on the Second Amendment, and you had Kennedy v. Bremerton, which was a landmark Establishment Clause case. In the span of 3 days, the court overturned half a century of precedent on abortion and substantive due process, more or less Second Amendment, and Establishment Clause / Speech Clause. These were very big cases. Last year, there was nothing quite as radical, but there were still some cases we can talk about. The Supreme Court's often called the MAGA court. The MAGA court. That simply is just not accurate. It's true President Trump had 3 appointees to the Supreme Court, but they are not, as you might say, red hat wearing people. Each of the 3 Trump appointees truly has some mind of their own. They do, believe me. And they don't always vote as a bloc. And in many ways, they're a bit idiosyncratic. Justice Gorsuch has his sort of quirks on Indian law and LGBT rights. Justice Kavanaugh has some of his quirks on federal courts, and he loves admin law. He loves set aside. He really does. And then Justice Barrett is the court's most, I'd say, unpredictable member. She was a law professor, like myself, and law professors tend to have minds of their own. And Justice Barrett really approaches each case as if it's a brand new case she's never thought about before, because it probably is. And she really tries to figure things out. And what's fascinating at Barrett is she actually is, and I love this about her, she's transparent. She is thinking out loud during oral argument. She thinks out loud in her opinions, telling her what we're thinking. The challenge is we don't know in advance what that's going to be. All right, so the biggest case last term, of course, involves administrative law. The court really focused on admin law last time. I think you start there. The landmark decision that sort of culminated decades of shifting was Loper-Bright. Okay, what's Loper-Bright? Loper-Bright involves Chevron deference. Now, you all took admin law before Loper-Bright, so you learned about this case called Chevron. Chevron was created actually during the Reagan administration. Maybe you didn't know that. It turns out that back in the day, we didn't have a Fifth Circuit, we had a DC Circuit. That was basically he's nodding, that was overruling every single regulation coming out of the executive branch. You had Judge Patricia Wald and others who said, aha, we know better than these agencies. So it's the Reagan Justice Department that said, we need a deference doctrine. That if there's some statute that, maybe it's a little ambiguous, that the courts will grant deference to the executive branch over how to proceed. In other words, the judges would not substitute their judgment for that of the administrative agencies when there's an ambiguity. And this was an opinion not by Justice Scalia, it wasn't the court, it was by Justice Stevens. So again, you had the Reagan Justice Department getting a deference doctrine from a fairly liberal member of the court. But over time, the views on Chevron shifted. Even Justice Scalia, blessed memory, came around on Chevron, started thinking, maybe that wasn't the best idea. And this culminated in the Loper-Bright case. The court granted cert on basically one question: do you overrule Chevron? And the court said yes by a vote of 6-3. Chief Justice Roberts, who, for whatever you say about him, he believes in independence of the courts. That is kind of his bread and butter. He really means that. And he wrote the majority opinion saying, no, it is for the courts to decide de novo the meaning of a statute or the meaning of a regulation. It's not the purpose of the agencies to do this. Justice Thomas wrote a concurrence. He thinks Chevron's unconstitutional. He thinks it deprives people of due process of law to put the thumb on the scale on the side of the government. Justice Kagan, who was an admin law professor, was not happy. There's sometimes you tell Kagan's a little bit upset, and sometimes she's really mad. This was Mad Kagan. It's like Mad Max. She was really mad because this was basically taking a hatchet to the entire body of law that she's been teaching about for her entire adult life. But in candor, I don't know, and I know there are judges in the room, I don't know how much of a difference Loper-Bright will make. I think judges who are so inclined can still say, no, we are reviewing the statute de novo, and wouldn't you know it, I agree with the agency. So I think that Chevron and Loper-Bright may have a similar practical effect as Heller. We kind of make this brand new area of law and things sort of stay the same they were, but we'll see some studies. Under Chevron, the government wins, not quite 100%, but close enough to it. We'll see if the prevailing rate for the government changes under the Loper-Bright regime. Another big admin case, separation of powers case, involved the SEC, an agency you probably all know well. The Constitution guarantees the right to a jury trial. It's right there, 7th Amendment. You can invoke it in any federal courts, ask for a jury trial, but if the SEC brings an enforcement action against you, well, there's no juries in the SEC. You have these in-house administrative judges. There's no jury system. You can't get your 7th Amendment right. So the question is, does the 7th Amendment guarantee a right in these administrative proceedings? Again, Chief Justice Roberts said yes. A 7-3 court. They actually affirmed my Fifth Circuit here for once. We'll get to the reversals later. They affirmed the Fifth Circuit here. And the Chief Justice says, when you're seeking civil penalties, that is akin to a suit at common law under the 7th Amendment. Therefore, you have the right to a jury trial. This one will make a difference. I'm not sure about Chevron. This makes a difference because there are many administrative agencies that do not give you a jury trial right. This will force the SEC and other agencies to bring actions in federal court and not in their own in-house administrative law judges. You can imagine why if you're a private citizen, you want a federal judge, Article 3, independent, and not some ALJ who works for the administration. For the administrative agency, I shall say, but effectively does work for the people trying to put you in jail, as it were, or impose a fine. Okay? So that's Jarkisy. Another case involves the appropriations clause, CFPB versus CFSA. Another agency you all know, there's a banking organization next door, the Consumer Finance Protection Bureau. Excuse me, sorry, I didn't mean to cough. The CFPB. That's kind of funny, actually. The CFPB. This was Elizabeth Warren's brainchild, and it regulates almost every facet of the financial industry in this country. This agency is like the perfect storm of unconstitutional, almost everything about it. As it was originally structured, there was a single director with for-cause protection. The court found it was unconstitutional a couple of years ago. But another facet of the agency was its funding mechanism. Most agencies, if you want money, you go to Congress every year or two, you ask for funding, you ask for a budget. No, not the CFPB. They get to basically set their own budget and take money from the Federal Reserve. There's a ceiling, you can't request above the ceiling, but they don't have to go to Congress. So an entity that's regulated went to the courts, my beloved Fifth Circuit, and said, aha, this violates the Appropriations Clause. Appropriations Clause puts a limit on how much money can be retracted without going to Congress. The court ruled by 7-2 vote that this was valid, Justice Kagan had the majority opinion here, and they said that going back to the framing, to the 1790s, you had agencies making kind of these open-ended requests that didn't have to go to Congress for these particulars. Justice Alito dissented and said that this is basically very unconstitutional. You can't have this separation of powers. But look, I'm sorry, Justice Thomas wrote the majority opinion. I'm sorry, I said Kagan, I was wrong. This was Thomas. This is an area where Thomas and Alito are disagreeing on a very big separation of powers issue. So I think this always shows that originalists and people who are originalism inclined don't always agree on these big questions. People say, oh, that's a knock on originalism. No, that's good. Show me how often Sotomayor and Jackson disagree, right? Show me. There are a couple I can tell you there are, they're not very often. But in a big separation of powers case, Thomas, Gorsuch, and Alito are on different sides. I think that's healthy for originalism. Okay, one last sort of admin law case that I actually took an interest in was Garland versus Cargill. This involves a bump stock. Do you actually have a bump stock? I want to ask. I've had students who've had them. A bump stock is a device that you install at the end of a rifle. And I'm going to describe it to you. It's a little bit hard to describe. You put this stock on your shoulder, and when you press the trigger once, the gun kind of goes back, and then it lurches forward, and then in the process it comes back again, and your finger hits the trigger again. And this goes over and over again. It lets your gun look a lot like a machine gun, except each time your finger hits the trigger, another bullet is expelled. Why am I being so particular with the description? Because under federal law, generally speaking, you can't have a machine gun. You get a tax, license, whatever, you can't have a machine gun. But the definition of a machine gun is that when you pull the trigger once, many bullets will come out. But here, with each function of the trigger, one bullet comes out. Again, this was a Fifth Circuit case. Fifth Circuit ruled that the feds cannot regulate the bump stock as a machine gun. The Supreme Court affirmed. I voted 6-3. Again, Justice Thomas wrote the majority opinion. This thing was a straightforward textual issue. There's a single function of the trigger. Boom, boom, boom. One bullet comes out at a time. Okay? Justice Sotomayor dissented and says, if it looks like a duck and it quacks like a duck, it's a duck, right? Well, not exactly. If you say a duck-billed platypus, not a duck. It's true. Anyway, one last admin case I'll mention briefly. This one actually matters to real lawyers. Corner Post versus Federal Reserve. This is actually a really big case. This was Barrett. This was a sleeper of the term. So when can you challenge regulations? So there's a statute of limitations, 6 years, that says, when you're affected by the rule, okay? But what if your business was not in operation when the rule went into effect? What if there's a 20-year-old reg and you incorporated yesterday and you're subject to it? Can you challenge a 20-year-old reg that went into effect a long time ago? Barrett says, yeah, you can. This is the biggie. If you combine Loper Bright, no deference, with this expanded statute of limitation, there is an entire cornucopia, Thanksgiving reference, entire cornucopia of regs are now subject to review that will not get deference. And even if they had deference 20 years ago, they will not get it now. So this is like what makes the chamber salivate. They love this case. And I think you'll see a lot of litigation based on the Corner Post SOL, because government might be SOL. All right. Excuse me. Let's do the First Amendment for a bit. I'll do next choice last. I'll save it for last. First Amendment. Murphy versus Missouri. This is one of another Fifth Circuit cases on the court's menu. We had a pandemic, you might recall. Remember that? It was a big thing. And if you tried to put on your Facebook page anything with vaccines, anything critical of vaccines, or critical of mask mandates, or critical of, where was COVID from? Did it come from a lab in China or from a wet market? I don't know. You would be shut down. Your post might be deleted under community rating standard. Maybe you might be deactivated. Your account might be demonetized. It means you can't earn ad revenue on your videos and content. So we all know that the First Amendment doesn't apply to private actors like Facebook and Instagram and Twitter. But these entities were not acting alone. There were phone calls being made from the administration, from the Surgeon General, from the FDA, saying, we don't like these posts. We think these are very harmful. They're misinformation. I love that word. Misinformation, which turns out to be maybe accurate a couple years later, right? So we just don't want to see these kind of posts. And there are just mountains of these sorts of communication through FOIA that have been released in Discovery. And so, of all places, Missouri and some other private citizens brought a lawsuit against Murphy, who was the Surgeon General, and they challenged it in federal court in Louisiana, because this is how things work now. Yeah. And they said, this is an example of jawboning. Jawboning? I actually have never heard this word before this case. Jawboning is when a government official calls a private citizen to berate them. They don't actually tell them what to do or give them an order, but they at least imply that if you don't do what I want, things might become unpleasant for you. Who's got one of those phone calls before? I have. Some government officials, who's made those phone calls? I bet you have. Government officials know to make these calls. Not looking for hands in that one. I've gotten those phone calls before. They're not pleasant. It's like, oh, I saw your blog post, Josh. Never goes good from there. Anyway, my beloved Fifth Circuit ruled that this was a violation of the First Amendment through this jawboning concept. The Supreme Court never got to the merits. Justice Barrett wrote the opinion for a 6-3 court, reversing the Fifth Circuit on standing. Now again, Barrett was a Fed courts professor. She is a stickler for standing. And frankly, I've never seen an opinion like this in my life. There were thousands of pages in the record of how government officials were basically jawboning these officials to nudge them to take content down. Barrett went through every single thing. No standing here, no standing here, no standing here. And then she's again, don't decide the merits. Alito wrote this dissent, and he was so incredulous. He says, how can it be that there's no one in the world injured by this? And in my view, maybe I'm wrong, I think Barrett leveled up the standing inquiry just a tad from where it's been before. Okay. Linkey versus Free. This is kind of a fun case about social media. You've seen this before. Local official from the school board has a Facebook page. They post information about their campaign, but also they post pictures of their kids. You know, this happens all the time. But then some constituent starts flooding content on their page, garbage floating around, right? So I bring all this garbage on their Facebook page, saying, how dare you do this, how dare you do that, and the guy's like, all right, screw this, block, right? Don't let you see my page anymore. Does that violate the First Amendment when a public official blocks a constituent from seeing their content? This issue came up during the Trump years, if you recall, right? President Trump blocked people criticizing him on Twitter. It never got to a clear resolution because he left office. Here the court sort of said, well, you know, blocking might be state action, but we don't really want to tell you why. So let's give this multi-factor test and let's leave everyone in sort of safe uncertainty. That's Justice Barrett's opinion for 9 members. Look, this was not an easy case. I'm actually not criticizing Barrett here. I don't think there was agreement on this issue. So they kind of just put out this wishy-washy test, like go figure it out, you guys. Lower court judges, have fun. So this was not one of the clearer cases of the term. All right, let's go to the one we can talk about here, which involves sort of the tete-a-tete between the 5th and 11th Circuit. Net choice. So Florida and Texas enact laws that regulate social media entities. The laws are not quite the same, but close enough for our purposes here. So for example, if the Facebook wants to take down a post, they have to give you a reason why. They can so-called shadow ban, all these things that they cannot do. So the question is, does this violate the First Amendment? The 11th Circuit held that no, there's not a violation of the First Amendment. It was a Newsom opinion, right? Yeah, so Judge Newsom, who's not in the room, wrote an opinion. I can criticize him, no. Judge Newsom I will not do that here. Judge Newsom wrote an opinion saying this is consistent, this is unconstitutional under the First Amendment. 11th Circuit, it was a panel with Judges Oldham and Jones, and they ruled that no, this violates the First Amendment. They said that Facebook is basically a common carrier and it can be regulated as such. So what does the Supreme Court say about the First Amendment issue? They actually don't. This was another frustrating case of the term. It turns out that some of the smartest judges in the country missed something. Look at you, Judge Newsom, who's not here, right? You missed it. Net Choice brought a facial challenge. I mean, we're talking about Paul Clement. He's a pretty smart lawyer, I think. Yeah, I mean, counsel from that choice, right? Smart lawyer. He screwed up too. And Fifth Circuit, you missed it too. Andy Oldham, Judge Jones, he's a smart lawyer. Judges, right? You missed it also. That this case should have been brought not as a facial challenge, but as an as-applied challenge. And therefore, we're just not going to decide it. Man, what a letdown. We're like, we don't want to decide this case. Go away. Let's make some stuff up at facial challenges. I'll come back to that later with Rahimi. This was sort of disappointing. But there were concurrences not to be disappointed. Justice Barrett wrote a concurrence. Justice Thomas wrote a concurrence. And Alito, Thomas, and Gorsuch wrote concurrences also. So here's what happened. And by the way, I speculated about this, and then Joe Biscupic backed me up. Originally, Alito had the majority. He lost it because Barrett fractured off with Kagan. So originally, Alito had an opinion which went on this facial as applied thing, but also said that the Texas law is probably valid. Barrett initially was at least Alito curious, but then she went to Justice Kagan and fractured off. Sorry, I have too much fun with this job, you can tell. So it started off as basically a very broad opinion, fractured off to this weird 9-0 ruling that made no sense. But anyway, you guys figure it out. So it goes back down to remand. I believe I talked to Erin Murphy about that. I think the amended complaint, if not been filed, we filed soon on this one. So this we litigated as applied challenge in the district court. Basically start from scratch. I mean, I just want to pause. The Supreme Court just sort of gets these cases, all right, whatever, remand. And then it's 5 years of litigation for everybody else. It's a burden, it's a tax. I mean, I don't want to just dismiss that. Sometimes just decide the case. You can decide this case. I think Judge Newsom's a very smart guy. He knows a lot about federal courts. I know he does. Judge Oldham knows federal courts. He teaches it. They all miss this as-applied thing. Give me a break. All right. That's not from the First Amendment. Let's do the second. Rahimi. Rahimi, meeny, miny, mo. This case is a letdown also, I think. So 2 years ago, Bruin was like the end of the world, right? Justice Thomas writes his opinion where he says, if we want to understand the Second Amendment, we look to history and tradition, okay? And we look for analogies. Is there some sort of analogy, an analog to the current law? So you want to ban carry in public today? What sort of laws ban carry in public in the olden days? And the court basically said there weren't such laws, right? You could ban carrying arms to terrorize people, but there was no ban on carrying in general. And I think that was a fairly easy case, as it were. My beloved Fifth Circuit. So shortly after Bruin was decided, we have the case of Zaki Rahimi. This is not a good dude. He is not something you want at your holiday party. He would shoot up a Whataburger. He shot at his girlfriend. He kept shooting people. He didn't actually hit them. I still don't get this. This man's been charged with attempted murder many times over, but he wasn't. For the life of me, I can't figure out why. Instead, the state seeks what's called a domestic violence restraining order against him, that he has to stay away from his girlfriend, okay, who he tried to shoot. Okay, that makes sense, right? If you try and shoot someone, you should be subject to some sort of process. But why don't they just arrest the guy for attempted murder? Again, I don't know why. But one of the consequences of being subject to a restraining order, which again is a civil proceeding, is you're a disqualified person under federal law. You cannot bear arms. You cannot have a firearm. Of course, he had a gun, and he was charged with violating Section 922G. The Fifth Circuit said, okay, let's follow Rahimi. Let's follow the Bruin standard. And under the Bruin standard, there is no tradition of taking a gun away from someone based on a civil order. You need either a conviction, a criminal conviction, but not a mere civil order. Goes to the Supreme Court. Court splits 8-1. Chief Justice Roberts gleefully writes the opinion. He just was so happy to write this one. And he says, oh, no, look. You know, the law is not frozen in amber. It's not like Jurassic Park, right? We get a little more flexible. So here's what Roberts said. He's so good. He drives me crazy, but he's so smart. He's like Houdini. He's like, don't look here, look over here. Right? It's misdirection. So he took two things. So you have these laws that said if you're a felon, right? If you're a dangerous felon, we can take your gun away after conviction. Okay, that's number one. And yet the other law is saying that if we think you're dangerous, you have to post a bond, a surety, in order to carry. Again, so in advance, you can post a bond, you can keep your gun. After conviction, we can take your gun away. He combined them. He said, the tradition of taking gun away before you actually before you're convicted. Again, there's a tradition of taking away your gun before you're convicted. No such tradition exists. He just combined two things that were completely unrelated. He said, that's close enough for us, good enough for government work. That more or less defenestrated Bruin. And who wrote the Bruin case? Justice Thomas. And where was Justice Thomas here? In dissent. That's how you know Thomas wrote the opinion. I think he knows what it meant. He's like, what happened, guys? Where are my bros at? Right? Where are my brothers? Where are you, Neil? Oh, Sam, where are you? Right? Why am I by myself here? What happened? This was 2 years ago. Justice Thomas was correct. He was all by himself. Rahimi in the Fifth Circuit was a correct application of the precedent, which was changed. So you can yell at the Fifth Circuit for other cases. In this case, I think they faithfully applied the precedent. Okay. Let's go on to something less controversial. Let's do abortion. Again, my beloved Fifth Circuit. That's like a running joke. FDA versus Alliance for Hippocratic Medicine. What is the Alliance for Hippocratic Medicine? You've never heard of it, I'm sure. It was an organization incorporated in Fort Worth. It's a group of doctors. Fort Worth, Amarillo, which is the wrong one. It was incorporated in Amarillo. It was a group of doctors who opposed abortion. Okay, there are lots of those. But they had a concern. They were concerned about mifepristone, which maybe you know what that is. It's a pill that can induce an abortion. And as with all medical products, this one in particular, there's a risk of complications. That if you take this one, you might have complications, you might have to go to a hospital and get treatment upon it. And these doctors were worried that if a woman should take this abortion-inducing pill and come to one of their hospitals or doctor offices, that they'd be forced to provide medical treatment, and they might have to facilitate an abortion. And even more so, under federal abortion laws, they were worried the feds might make them perform the abortion, even though they have conscious objections. So what remedy did they seek? Again, these were not people who actually were taking the pill themselves. These weren't their patients taking the pill. They were just worried that someone would come to their office and seek treatment. They sought to impose restrictions on the availability of this drug. They said that the original FDA approval was not valid. They said that it should not be available through telemedicine. They did an in-person visit, and they tried to restrict access to it. The district court said yes across the board, take it off the market. The Fifth Circuit reversed in part. The Fifth Circuit said, well, you can keep on the market, but some of these more recent ones, the statute of limitations, those can be rescinded. This one went 9-0. This one stung, right? This was a 9-0 reversal. Justice Thomas concurred, basically saying, yeah, even I'm with the majority in this one. Justice Kavanaugh with the majority opinion, and he's like, no, we don't allow such attenuated chains of reasoning, what might call probabilistic standing, right? That, well, maybe if this happens, and if this happens, and if this happens, I'll suffer an injury, right? There are too many links in the chain to get there. Just one modest defense of the Fifth Circuit here, which is not big, which is a modest one. During the oral argument, Justice Kavanaugh and Justice Barrett badgered the SG, the Solicitor General Prelog, who's quite good, and said, so would the federal government make a doctor perform an abortion? And she's like, well, I don't really want to answer your question, Justice Kavanaugh. And Justice Kavanaugh asks again, but can you just represent on behalf of the government? And that's like the, when the justice says, what's your representation? You've got to answer that question. And Prelogger said, we likely would not do that, Your Honor. She said, we likely wouldn't do it. And Kavanaugh puts in the opinion, the government represented they would never do this. He does this all the time. Did this in the next case also. He's good at this. And he did this also in the ghost gun case last month. Kavanaugh, he jawbones the SG at the podium. You want to see jawboning? That's Brett Kavanaugh. In fact, Kavanaugh was the White House secretary for George W. Bush. He jawboned, and he actually said this during the argument. He's like, well, I make these phone calls all the time. I bet you did, Brett. You're doing it right at the podium. I know all about it. So Kavanaugh, to his credit, jawboned a bit and got some relief from Prelogger. So at least if you're a doctor in this group, you have a conscious exemption. You want to perform the abortion. So at least there was, the case changed a bit. Another case also involving abortion is Moyle, not like the one at Abris. This is M-O-Y, thank you, my one G in the room, M-O-Y-L-E at circumcision, right? M-O-Y-L-E from Idaho. This involves EMTALA, the Emergency Medical Treatment Active Labor Act. This was a law passed during the Reagan years that said that if you show up at a hospital and you have some sort of emergency condition, they have to treat you. They have to stabilize you. That's where it's stabilization, which I guess makes sense. You know, people dying on the curb who don't have insurance. But shortly after Dobbs, the Biden administration said, aha, stabilization, that means abortion. So if a woman shows up at a hospital and she wants to have an abortion, some sort of a condition going on, you have to provide it. Even if you're a Catholic hospital, for example, that doesn't provide abortions. Okay. This is another case where the court did some weird stuff. Those were dismissed and privately granted. I don't want to go to that. But again, Kavanaugh and Barrett jawboned the SG and said, what about the conscience protections? Would doctors be forced to provide abortions to get their conscience? And again, Pre-Lager kind of hemmed and hawed, but eventually said, no, we probably wouldn't do it. And they said in the opinion, government said we will not do this. So even if you're a hospital and you're the only doctor on duty, you have a conscience protection, you have to do the abortion. So that actually gets a long way to what actually the plaintiffs wanted. All right, I know we have a few minutes left. Let me wrap up the rest of the cases. Eighth Amendment, Grants Pass versus Oregon. This is a really fascinating case. And actually, just pause for a minute. Most cities and towns have bans on public camping, right? You can't camp in public. Okay, they're not really worried about people like the Boy Scouts pitching tents. They've been homeless people, let's just be honest, right? And the law says you can't sleep in public. Okay? If you don't have a place to sleep, where are you supposed to sleep? Right? Again, if the state doesn't have a homeless shelter in your jurisdiction, we all need to sleep, right? We all sleep at night. And you can't sleep in public, where are you supposed to sleep? It's, putting aside policy, it's actually a very difficult question. How do you deal with people with no place to sleep when you're not giving them a bed to sleep in? Okay, but this is a different question from policy than the Eighth Amendment. There was a case from the 1960s by the Warren Court just made up called Robinson versus California that said the state cannot make it a crime to become a drug addict, right? It wasn't just a crime to possess drugs or use drugs, the crime was being a drug addict. And the court said you can't do that. It's a state of being. You can't make a crime for just who you are. Probably wrong, but that was the precedent. In this case, the issue was, did the city violate the Eighth Amendment by basically criminalizing or imposing tickets for being in public where you had nowhere else to go? Court split 6-3, Justice Gorsuch writes the majority, Sotomayor dissent. This was a case where Gavin Newsom, the governor of California, is supporting the majority. And oh boy, Gorsuch was happy. He's like, let me quote Gavin Newsom some more. Here's California. Here's California. See, it's not me. Look, I'm just a great guy from Colorado. Here's all the California guys. So this was a 6-3 ruling. All right. And let's do Trump cases. Because none of these matter. There were two big Trump cases that seemed like such, just after Tuesday, these seem like they don't even matter. Remember insurrection? Remember that? I think last year on here, Jenny, we were talking about insurrection, right? This was a big deal. Chicago grads here, my good friend Will Bode, made a big deal about this. Whatever now. So the argument was that Donald Trump is an insurrectionist based on January 6th. It should be taken off the ballot. I filed several amicus briefs in this case. I think it might have had an impact. But ultimately, the court sort of punted the issue. They said, well, we won't decide what insurrection means. We won't decide if the president's subject to it. We'll simply say that Colorado, you can't do this yourself. It's for Congress to do. That was a punt. It was a risk because the court's basically saying, please don't let this issue come back to us. And I think now it will not come back to the courts based on the Electoral College, I won't say landslide, but the Electoral College victory and the fact that the Senate will be Republican controlled. I don't see any circumstance where this election goes to the Supreme Court based on insurrection. Now, when Trump's in office, some will say, aha, I will not follow this executive order because you're not really the president. And know what John Roberts is going to do? He's like, oh, political question, right? Political question. Congress certified the election. That's enough for me. So, sorry, Will, this will not come back. We're done. The other Trump case also seems to have an afterthought. Trump against the United States. This involves presidential immunity. This has been described as like the worst case ever. I don't get it for the life of me. We have Nixon versus Fitzgerald, a case from 1982, which says the president has absolute civil immunity for his actions in the perimeter of his office. Again, absolute civil immunity. If that's the rule, Why would he not have the same for criminal liability? Criminal is a heck of a lot worse than civil, right? With civil, you can settle it, right? Paul Jones, just pay her off. With criminal, you go to jail, unless the government wants to make a deal. You go to jail. And the court ruled by 6-3 vote that criminal is actually, if not worse, at least just as bad as civil, and the same immunity ought to attach. And the Chief Justice said, for actions within the sort of this, you're not really sure if it's official or unofficial, they're presumptively immune. This decision, I think, will fall out of relevance. People won't talk about it much. It's not that big of a deal. All right, I have only a moment left. Big cases coming up for this term. One is called Garland v. Vanderstock. Nothing goes comes back from the lawyers in this case. It was argued. We'll see how it goes. A big one, Scrimeti. Ooh, this one might change. No pun intended. Involves transgender minors. Can Tennessee ban medical treatment for transgender minors? Now, the reason why it might change is that we'll have a new sheriff in town in a few months, right? The Trump DOJ may come in and say, you know what? We don't want to challenge Tennessee's law. We think this law is actually constitutional. So that might be a dig, might be a months where they might just take it off the docket. So there are actually a number of cases brought by the Biden DOJ that might just disappear in January. What happened? The phrase is, upon further reflection, the SG has changed positions. Upon further reflection means upon further election. That's the rub. Another case also from Texas, lots of Texas, Free Speech Coalition versus Paxton, which involves restricting access to pornography to minors. So if you want to access a pornography site in Texas, you need to verify your age. Kind of a weird First Amendment issue, not the usual one. Okay, one last case, medical marijuana v. Horn. Anyone do RICO litigation here? RICO is very lucrative because you get treble damages. But there's a limitation that you can't use RICO for personal injuries. This case is kind of a weird fact pattern. Truck driver has a back injury. He wants to use CBD. It's advertised, there's no THC in here, you'll not test positive for marijuana. Guess what? There was THC in there. He tested positive, lost his job as a truck driver. Can they bring civil RICO, which is treble damages? This is a medical marijuana v. Horn. All right. With 3 minutes left, I will stop for questions. Thank you all so much. Please, questions? Yes.
I want to take your temperature on where you stand on some of these intra-originalist methodological battles that seem to be happening.
Sure.
On the justices, or between the justices on the court who profess to be originalists.
Yeah.
That could probably be a whole topic in and of itself.
It is.
So I'll just throw two different issues out there. One is the temporal component, about kind of where you go back to and how forward you go when assessing original public meeting, and then also the source component.
Oh boy.
What actually
He reads his opinions carefully. So let me try to make this so it makes sense to people who haven't followed this so closely. We have a lot of originalists in the court. They don't agree. And again, I meant this earlier. That's healthy. I think it's actually a good thing that even originalists can. Oh, feedback's something weird now. I don't know. That's actually a good thing that originalists can disagree. Justice Barrett and Justice Thomas are beefing. They are not agreeing with each other. And as I usually say, before I disagree with Justice Thomas, I want to be damn sure I'm right. I mean that sincerely. Justice Scalia told me to be damn sure I'm right. Barrett's sure she's right. And she made that decision very quickly. And it involves what is the correct temporal period, is your question. When we're interpreting the 14th Amendment, right, we're interpreting whether the Second Amendment applies to the states. Is a relevant framework, what did it mean in 1791? What did it mean in 1868? When you're interpreting the Second Amendment as applied to the federal government, the question is, what did it mean in 1791? Or can we look past it? In Heller itself, which Barrett's boss wrote, Scalia looked beyond 1791. He considered laws during the 19th century, during the antebellum era. And Justice Stevens said, how dare you, Scalia? We're originalists here, aren't we? We're looking only, and Scalia said, no, look. If there's a consistent tradition where the meaning stays fixed from 1791 to the 1820s, the 1850s, that actually makes my case even stronger. Barrett said, no, we're not going to do that. We're going to limit it to 1791. But the bigger conflict is between Barrett and Kavanaugh. Justice Kavanaugh is a good old boy. He loves tradition. He just loves things the way they were when he was a kid, right? You know, that's just like the apogee of society, right? And he likes tradition. Tradition, right, tradition. He likes tradition. Everyone laugh. Barrett doesn't like tradition. She wants to only look at meaning at the time. And this doesn't make a difference in a lot of cases, but it fractured in Rahimi. And in the case of Vidal v. Elster, E-L-S-T-E-R. This was a sleeper case of the term involving IP, right? And Barrett and Thomas are going at it. You want to know who's enjoying this fight with the popcorn? Kagan. Kagan's like, yeah, Amy, you go, girl, right? We'll just go with you, whatever you say. And I've actually made this analogy. I think Kagan is just like trying to fracture apart the court's originals. It's actually very smart. It's ingenious, right? Alito is, again, what he calls himself, a pragmatic originalist. He doesn't get into these weeds. Gorsuch tried to make peace in Rahimi between the Barrett and the Kavanaugh and the Thomas, and I don't think he did much of anything there. So this could be a big deal. Look, when you appoint originalist judges to think for themselves, this is what happens, right? And, does the next administration even care about these things, or do they just appoint people who sort of, we'll see. Yes, sir.
I noticed you did not point out the part of the opinion in that choice where the Supreme Court said, well, when we remand these cases to the 5th and the 11th Circuit, we want to make clear some basic First Amendment principles that the 11th Circuit largely got right and the 5th Circuit got completely wrong.
Yes, the majority. The majority absolutely endorsed the reasoning of the 11th Circuit, and the majority absolutely rejected the reasoning of the 5th Circuit. You are correct, sir. Thank you. Thank you for that modification. I have to move so quickly, but I omitted a part that I probably should have mentioned. Thank you. What other questions do we have? Yes, sir.
You started out with Chevron and then moved on to bump stock, and in the first Trump administration, outside of core presidential powers, or at least arguable ones like tariffs and immigration enforcement, the Trump administration deferred to Congress. But there's a rumor, unsourced, that the Trump administration was asked to issue the bump stock ruling so Republicans wouldn't have to vote on it.
It gave them cover, yeah. No, it's not a rumor, it's true. I did an amicus brief. So I say, oh, Josh, you always support Trump. Actually, it's not true. I filed an amicus brief against the Trump administration, the bump stock case. Go figure. The issue here is that after there was a mass shooting in Las Vegas, remember this one, where this awful human being was in a hotel building at a very high floor, and he basically was firing upon a music festival, and he had a bump stock, and he just mowed people down. This was just gruesome. After this happened, there was reasonable cause in Congress to ban these devices. Look, which I'm not sure I'd oppose that statute. Maybe I would, I don't know, I have to think about it. But Trump basically said to Republicans in Congress, no. You don't do it. This puts you guys at odds for the midterm elections, right? I'll do this one. I'll go do it through executive action. And there was actually a meeting, it's recorded, it's on C-SPAN, you can watch it. I think it was John Cornyn saying, well, Mr. President, we can do this under the Gun Control Act. And Trump's like, no, I'm gonna do it. That is backwards. We need congressional supremacy for laws. And I think this actually makes it even harder to challenge. In other words, if Congress thinks they need a statute to do it, that's some good evidence that the president doesn't have the power already. In other words, if Congress wants to act, that means the power is currently lacking. But unfortunately, the president went alone, and then Biden defended the regulation, and he lost to the federal court. That's where we are. Yeah, Craig?
What do you think about those kind of arguments?
Again, I'm one of the lawyers in that case, so I'm just going to demur, but I'll let you review the transcript. Yeah.
So you spoke about shadow banning earlier, the issues that come up with social media lately. What do you see the court kind of taking in that regard? Do you think the Marsh opinion will play any role? The Marsh opinion? The Marsh opinion? The Marsh, they're calling the private city, which, even though it's a privately owned city, it's operated as though it was public, it was going to be treated like a public forum. Yeah, arguments that social media companies, although they're may be a private company.
So look, I'll admit. I think that weird. The question was, does Facebook resemble sort of these private company towns where they have full control, or is Facebook like a social media, a common carrier or public utility? or a newspaper. I mean, that's the vibe, right? What's the analogy? So under Miami Herald against Tornillo, right, you had a Florida law which mandated that newspapers post basically responses to critical pieces from government officials. And the court said, no, you can't do that, that the newspaper has limited column space, you can't dictate how they use their spaces, right? But then you have Pruneyard, another case I was never much of a fan of, which involved a mall, and basically you had these people handing out leaflets and information at a public mall, at a private mall, and they said, get out, no soliciting. The court said, no, you've opened your space up. So the conflict is Facebook more like the mall in Pruneyard, or is more like the newspaper in Tornillo, or it's more like AT&T, the phone company? Barrett and Kagan think that it's like a newspaper. Alito, Gorsuch, and Thomas think it's more like a public utility. I'll leave it there. What other questions do you have? Yes, sir?
Why do you think Amendment 7 is not allowed in the U.S. Court of Federal Claims when the only appeal is through the Fed Circuit and Supreme Court, so somebody does not have rights to trial?
Oh, isn't that because it's not a public right? It's a private right? Someone's nodding. Yeah, there's this entire doctrine about the Seventh Amendment, whether it's a public right or private right. And I think by all the cases in the Court of Federal Claims are private rights, is that the rights created by government actions, that they don't have a Seventh Amendment. I think that's right. The Court of Federal Claims is an Article 1 court, it's not an Article 3 court, so it stands in a similar fashion. Now, what's unique about the SEC is you're imposing these penalties for your your own conduct, so I think it's different. I don't know, I'd have to look at that more carefully. Okay. Yeah, what other questions? Yeah.
Court of Federal Claims, one area that might be noted is limit atheist, because that is the individual. It's not the contractual.
I don't know. I don't know those particular ones, but that might be an exception. I don't know. What other cases do we have? Jane, are we done? Thank you all so much.
Now, real quick, I have a few of the Coolidge reviews.